It is right at 11, so we will go ahead and get started. So today we're doing just a short seminar on who needs an estate plan, who needs a will, what is the purpose of it. And instead of going through a bunch of slides today, I kind of want to just give you real life examples of things to look out for and things that have happened to people when they didn't have estate plans and weren't sure what the consequences would be. But just a little bit about me. If this is your first time tuning in to my webinar, my name is Lauren Ward. I'm a managing member at a business law firm here in Spartanburg, South Carolina. I practice in the areas of estate planning, Medicaid planning, and business planning. I'm a graduate of the University of South Carolina School of Law, and I've been practicing in Spartanburg for most of my career. So that's just a little about me. But today we're really going to talk about estate planning and who needs it and why someone would need it. So the first thing we need to know is, what is estate planning? Estate planning realistically is just the documents you need so that your assets can be passed on to your family when you're no longer here, or whoever you choose, maybe charities, maybe not family, maybe friends. And then there's documents we have that are part of life planning. And that's things like your healthcare power of attorney and your durable power of attorney. So that way you have those that if you become incapacitated, somebody can make decisions for you. So instead of going through each of these documents individually, because we have other webinars that go through that, I want to kind of touch base on real life scenarios on what happens if you become incapacitated and don't have these documents, or what happens if you pass away and don't have a will. So I kind of want to break that down for everybody. So the first thing, let's think about this situation. There is an elderly person, let's just name him Bob to make it easy. Bob gets dementia, and Bob cannot pay his own bills because he has dementia. He doesn't know how to do it. He can't make sure his finances are being managed. We're worried about people taking advantage of him because elder abuse is a big area right now that people are having to deal with. So we're really worried about Bob, but he's a widower. He is the only one on his bank account. And he has these bills that have to be paid, and he has say he's got retirement accounts and these need to take these RMDs from it, but he doesn't have a power of attorney. So his financial advisor is saying, I can't talk to you. There's no power of attorney. I have no authority to do this. The bank's not talking to you because you're not on the bank account. You can't write checks. If you wrote a check and signed his name, that's technically fraud. So you're having to deal with this situation because there's still bills that need to be paid. There's still finances that need to be taken care of. There is still stuff that needs to be done for Bob, but we can't do it because we don't have a power of attorney. And so what would have to happen in that situation is that we would have to do a conservatorship with the probate court. And in the conservatorship, this would mean that the court has to go through and appoint someone to be over Bob's finances. Typically, they're going to look to the next of kin. Maybe that's not really who Bob wants. Maybe oldest child is not able to handle it. Bob really wanted middle child, but the court's just going to make everybody apply. It's going to be a formal proceeding. There's going to be lots of costs. There's going to be a doctor having to handle all the affidavits and everything to show that this person is truly incapacitated. And it's a formal court proceeding. And this is also not fun for Bob because you're going to have to show that he's mentally incapacitated and can't handle his finances for himself. And at this point, what would happen is the court is going to go through this proceeding, and maybe they find you have to do sled checks, credit checks, and all this stuff. You possibly have to get bonded or set up certain accounts to be able to handle these conservatorship accounts. And finally, Bob's going to have somebody appointed for him to handle his finances. And hopefully it's who he would want, but sometimes it's not. And that was a really expensive procedure. And on top of that, this person constantly has to check back in with the court, gets court's permission to spend certain amounts of money, gets court's permission to deal with real estate. So it's really even though you've got the conservatorship, it continues to be ongoing work for this family member or whoever was appointed as a conservator. Maybe the court didn't like any of the family and appointed a third party fiduciary to handle this, but it's going to be an ongoing process. And so it's not just a simple one-time thing, it is a true court proceeding. How this could have been avoided is if Bob would have done a power of attorney while he had mental capacity. He could do a durable power of attorney, which would allow somebody to handle finances for him if he became incapacitated and was unable to handle those for himself. I've seen this happen many times. People just don't get those powers of attorney done. And then they have life issues such as dementia, or they're just become incapacitated and they can't do it anymore because they don't have mental capacity. So the family has to go through this whole proceeding, which is a lot harder, a lot more expensive, and not fun for anybody involved. So the way to avoid that is to do that durable power of attorney while you have mental capacity. It's a lot cheaper, a lot easier on your family. And that way your family can handle your finances, or you don't even have to appoint your family. You can appoint whoever you want. And that's the nice thing about it. You have the power to pick who you want to handle your finances if you're unable to. And the important thing is to make sure you pick somebody you trust and to make sure you have somebody that understands finances and how to balance their checkbook. That's a real life example I've seen way too many times where people don't have a power of attorney and then something happens. And a power of attorney is good to have whether you're 18 or 100, because you never know what tomorrow holds. If you're in an accident and you're going to be fine, but you're in a car wreck and for a while you're incapacitated, the family still needs to be able to handle your bills. So it's important to go ahead and have that power of attorney, even if you're younger, because it's a document we all need. And while we're talking about powers of attorney, we have the same situation that you need to have a healthcare power of attorney. This is to appoint an agent to allow medical decisions for you. Real life examples of this. With your healthcare power of attorney, you have inside of it what's known as a living will. And with this, you get to make decisions on life support and feeding tubes. While not fun to think about, it's important to, have these conversations with your family and think about them. Because in real life situations, many children have gotten into arguments about whether or not to remove life support from their parent. It hurts families. It makes children fight because one child doesn't want to remove it and one child does. And it makes it a hard time for families. When you have a healthcare power of attorney, you can appoint who you want to make the decision. So maybe you trust Judy instead of John as your children to make this decision. But also inside of that healthcare power of attorney, you get to decide if you want life support or not, or if you want feeding tubes or not. So you can go ahead and make those decisions to take that burden away from your children. So in that situation, you're really protecting yourself to get what you want in the medical line of care, and you're protecting your family to make sure they know what you want and need. I have seen many arguments among families dealing with these medical situations. And you can take all that away by just doing a simple healthcare power of attorney. If you don't have those, you may have to go through a court proceeding known as a guardianship, very similar to that conservatorship. Very expensive proceeding. We have to have doctors have reports that say you're incapacitated. It is not fun for anybody. So those are two documents that are just vital for everybody to have, because we never know when we're going to have those needs. And you have to make sure you do those documents while you still have mental capacity to do so. So it is important to make sure you get those documents while you have mental capacity. Real life examples, people don't have them and we end up in court. And I have seen many times siblings argue in court and it gets nasty and messy and it is not fun. It can break families apart. There have been sisters who have had to litigate who gets to be conservator for mom and have a week-long trial. And that's not something any of us want to deal with or want to have happen. So doing those powers of attorney really protect not only us to get what we want, but also our families as well. So that's on the life planning side of things and why everybody needs that. When we think about estate planning, a lot of people think, I don't need this. I don't have a big estate. I don't have a lot of assets. That doesn't mean anything. Everybody needs at least a basic estate plan. For instance, real life, dad and mom married, have 2 kids together. Dad passes away, children are minors, no will. Rules of intestacy, which is the South Carolina Uniform Probate Code goes by intestacy. Half the assets go to mom, half the assets go to children. Children are minors. We end up in a conservatorship for minors, having to have these assets held till they're adults, very complicated proceeding. You have to have permission, like in the conservatorship for adults, but these are even a little stricter because we're protecting minor children. Have to have court permission to spend money on anything. You're really going to be going to court a lot to deal with this. Easier way to handle it, have a will. Everything goes to mom. And if mom and dad pass away at the same time, you have a trust inside of your will to protect those minor children. This also becomes really important when you have children who have disabilities, who may be receiving SSI. In those situations, if they receive this inheritance, it could hurt their SSI and they could lose it, or they could have to set up a first party special needs trust in which Medicaid has a payback provision. You don't want to have to do that if you don't have to. So the way to fix that, have a will and put a trust inside of your will for that child. You don't have to write the child out of your will. You just need to have a trust in there to protect them. That's an example of why everybody really needs a will in those situations. Another example that happens a lot in real life, you own a piece of real estate. Real estate has expenses to it. So for instance, there's insurance, you have to pay taxes, possibly a mortgage. So there's all these expenses with a piece of real estate and you pass away. If you don't have a will that gives your personal representative the power to sell your real estate while it's in probate, they actually have to file a formal petition and get permission from the probate judge in order to be able to sell this piece of real estate. That adds time to it and expenses. It could take 2 or 3 months possibly to have this petition signed. Hopefully not, but it could, depending on if anybody objects and those type situations. But if you had a will that gave your personal representative power to sell this piece of real estate, they could go ahead and sell it and put the money in the estate account and save the estate those insurance, taxes, and all the other expenses that go with upkeeping a house, especially if no one in your family wanted the house and you knew they wanted to sell it. Just having that will and giving them permission to do so makes a huge difference to your family. Those are some really common situations we all probably deal with the reasons we need a will. We also need a will if we have minor children, because we want to make sure we pick the guardians for them and make sure that if something were to happen to us, our assets would be held in a trust for them until they're an adult. So they don't have to go through that conservatorship for minors, but can just handle it through the trust. And we also pick the guardians we want, so our family knows who we want to be guardians and who we want to take care of our children. So it takes a lot of drama away for the family, takes a lot of arguing away, and having a will just helps. A lot of times people don't realize that the spouse gets half and the children gets half. And this happens a lot of time in second marriages. You think that your spouse is going to get this house because you think, oh, we're married, it's automatically going to go to them. And then it doesn't. And maybe stepchildren come in and don't want stepmom or dad to have this house, and it ends in litigation. And mom having to spend money that, she already had invested in this house, but double investing it to buy out stepchildren's interest in the house. So those are all really big reasons we need to have a will, aside from the fact that we just want to protect our assets and tell who we want to get them and who to be guardians of our minor children if we have those. But those are real life examples we see a lot. A lot of times people wonder, well, do I really need a trust? Or should I have a will? What's the difference? Simply put, a trust lets you avoid probate. So it's really personal preference. Do you want to avoid probate or not? Realistically, with avoiding probate, it can make things quicker for your family, make things easier. Probate's about a year-long process, give or take, and that's without litigation. That's without any of the hard stuff. That is just a very simple probate. When you have a will, it's still going to be about a year-long process. A will doesn't make you avoid probate. A will just allows you to tell probate how you want your assets distributed and not through the laws of intestacy, but you are still going through probate. Having a trust lets you avoid probate if you put your assets into the trust, because the trust is its own separate entity which can hold property, and that can tell you how you want your assets to be distributed. You can put real estate in a trust, you can put bank accounts, everything can possibly go in a trust. And so it's important to understand if you need a will versus a trust and personal preference, and to weigh the pros and cons of each. And that's an individualized decision for everybody to make. It's not a one size fits all. Different factors play into it. Wanting to avoid probate is a good enough a reason to have a trust if that's important to you. And for a lot of my clients, it is because they know probate takes a while, or because probate records are public and they may want stuff private. So it's a good enough reason for them to pay the expenses of having a trust, because a trust is more expensive, but it's enough reason. Sometimes the reason is I have a child who doesn't spend money very well, and I worry if I give them this $100,000 flat out, it'll be gone next week. So I want to have a trust to protect them. I want to have a trust that stands out for my minor children. Sometimes we want to have a trust so we avoid probating in multiple states or counties. For instance, if you own property here in South Carolina and then maybe you own a beach house in North Carolina, you're going to probate in 2 states. And sometimes that's really time consuming and really expensive, so you want to avoid it. Sometimes you're a business owner and you want to make sure that business doesn't stop with you. So you have a trust and you have the business owned by the trust to keep it going and moving forward. So those are all examples that happen a lot of times in real life. People don't want to probate in multiple states. People have children they don't trust, or people don't trust with handling large sums of money. People want privacy, or people just want to make it quicker and easier for their families to avoid that probate process. But it's not a one size fits all. It's important to have that discussion with your attorney to see what works for you. I think a lot of people think they don't have assets to fund a trust, and it's really not always about the size of your assets. Sometimes it's owning multiple pieces of property. Sometimes it's just like we talked about, simple probate avoidance. But that is definitely a conversation to have and lay out the pros and cons of each and what works for you and your family. Estate planning is never one size fits all. It's always different for each person, which is why it's important to talk to an attorney that understands this and can look at your situation and give recommendations based on what they've seen and what they know works, instead of using a one size fits all approach. Having that personalized approach really makes a difference. We all really need an estate plan. If you have children, definitely need one, because you want to protect those minor children. If you have any type of assets, you want to decide who gets them when you're no longer here. That's why you have an estate plan. And all of us need to have those powers of attorney, because none of us are guaranteed a healthy, happy tomorrow. So we want to make sure we are protected and we protect our families. So we have those documents in place for if something were to happen to us. Estate plan is not just for the wealthy, although it is important for everybody to have that estate plan. You may not have to worry about tax planning if you're not in that taxable bracket, which most of us are not right now. It is currently, the tax bracket right now is about $22 million for a couple, 11 million for an individual. So in those situations, a lot of us don't need the tax planning, but we still need planning to protect our families. We still need planning to be able to protect ourselves. So we may not need that complex estate plan with multiple trusts, life insurance trust, those type things, but we still need some type of plan. And sometimes you just wouldn't want your assets to go through intestacy, because maybe you want to leave funds to your alma mater. Maybe you want to leave funds to the Humane Society because that means something to you, or to your church. If you don't have a will or a trust that says this, there's no way charitable donations would happen through your estate, because it's going to go through the rules of intestacy. So I think all of us need to think about what's important to us, protecting ourselves for sure, and making sure we protect our families. We don't want to have arguments within our families. We don't want to cause drama between our families. Having that well thought out will or trust avoids this. For instance, you can use with your will or trust a personal property memorandum, and that's where you could think about those personal assets, like maybe your jewelry, your furniture, your antiques, your knickknacks, things that may mean something to your children. And you use this personal property memorandum and you write out all these assets to go to them. And it goes like it's just part of your will. And that can avoid drama with people fighting over your household items. There are plenty of times people will litigate over household items, but having this proper estate plan in place could stop that from happening. And I think we all want to make sure we're protecting our families and ourselves. And having an estate plan really does that. Having those living estate plan documents and having your true estate plan can make a difference and protect you and your family. We don't want to have the assets go to children when we're husband and wife and we want it to go to each other. We want it to go to each other, not our children, not how the laws of intestacy say. So coming down to it, it's a personal preference really between wills and trusts, but we all need some type of basic estate plan to protect us. It's not just for the wealthy. We all have assets. A lot of us have children that we want to protect. A lot of us have things we care about that we want to leave a legacy to, like doing gifts to the Spartanburg County Foundation or to Walford, Converse, Upstate, USC, Clemson, all these different schools you may have went to, caring about your church, different nonprofits in the area, mobile meals, habitat, those type of things you may want to leave assets to. So having that estate plan covers all of that for you. And it's important we each think about it and get that personalized approach to make sure we have an estate plan that works for us and our families. So it's important for us all to have it. And it's really a personalized approach, but real life examples show you if you don't have one, it's a lot of stress to your family. That is our quick little webinar for today. Instead of going through slides, I just wanted to kind of give you an overview of some problems I've actually seen practicing in estate planning, law, and probate. Please feel free to email me with any questions or to give us a call at our office. Let me get my information pulled up here at the end. So once again, I'm Lauren Ward with A Business Law Firm. My email is lew@abizlaw.com. Our phone number is 864-699-9801, and we are located at 1989 South Pine Street in Spartanburg. I'm happy to answer any questions for you all now, or if you have questions, feel free to email or give me a call. And this will be on our YouTube channel. So make sure if you think somebody needs to hear this, you share it with them. And we will be happy to hear from you. And thank you for joining us today.